Now that we understand how the marketplace influences strategy, we move into the legal document that launches the entire transaction, the residential listing contract exclusive right to sell rent. This is not just a marketing form, it is a binding employment contract between the owner and the broker. It establishes authority, compensation rights, fiduciary duties, and legal protections. Under ARS, Paragraph 44-1017, Statute of Frauds, an agreement employing a broker to sell real property for compensation must be in writing to be enforceable. If it is not written properly, the broker may not be entitled to compensation. Under ARS, Paragraph 32-2151.02 and AAC R428-1101, licensees must exercise reasonable skill, care, and proper documentation practices. Every line on page 1 matters. Let's walk through it carefully. Parties. Establishing who is bound. The identification of the owner-seller is critical. The listing agreement is only enforceable against the parties who sign it. If the property is owned by a married couple and only one spouse signs, you may have a defective contract. Arizona is a community property state under ARS. Paragraph 25-R-211. If the property is community property, both spouses typically must sign to create a binding agreement affecting the property. If the property is owned by an LLC, trust, or corporation, the signer must have authority. That is where the capacity section later becomes essential. The broker section must identify the licensed brokerage entity, not just the agent. Under Arizona law, the brokerage holds the listing, not the salesperson. AAC R428-1103 requires broker supervision and control. The agent acts on behalf of the brokerage. If the brokerage name is incorrect, compensation rights could be jeopardized. Example: an agent lists a property, but writes only their personal name and not the brokerage entity. The transaction closes. A commission dispute arises. The listing may be challenged because the employing broker was not properly identified. Discussion. Question: if a property is owned by a trust, who should sign the listing agreement? Answer: the trustee, signing in their capacity as trustee of the named trust. Documentation confirming trustee authority should be obtained. Property. Defining what is being listed. The premises section defines exactly what the broker is authorized to sell or rent. This includes real property, improvements, fixtures, appurtenances, and potentially personal property. Precision matters. If the assessor's parcel number is incorrect, the legal description is incomplete, or the property address is wrong, you may create confusion or even a voidable contract. Arizona courts rely heavily on legal descriptions. An incomplete legal description can create enforceability issues. Under ARS, paragraph 33-401, conveyances must contain a sufficient legal description. While this is a listing agreement and not a deed, clarity at this stage prevents downstream errors in the purchase contract. Example: a Gilbert property includes a detached casita with separate utilities. If it sits on a separate parcel and that parcel is not included in the listing agreement, you may unintentionally exclude it from authority to sell. Personal property inclusion is equally important. If the seller intends to include a refrigerator, washer, or leased solar equipment, clarity protects both parties. Discussion. Question: why is including the assessor's parcel number important even if the street address is listed? Answer: because legal ownership attaches to the parcel number and legal description, not merely the mailing address. Addresses can change, parcel numbers do not. Listing price and terms, creating the broker's authority. This section transforms the document from identification into a binding employment agreement. The agreement language establishes that the owner is hiring the listing broker to find a ready, willing, and able buyer or tenant. This phrase is legally significant. Historically, brokers earned compensation upon procuring a ready, willing, and able buyer on the seller's terms, even if the transaction did not close due to seller default. The exclusive right to sell rent designation is powerful. It means the broker earns compensation regardless of who finds the buyer, including the seller. This differs from an exclusive agency listing, where the owner could avoid paying commission if they find the buyer themselves. The warning about signing more than one exclusive agreement protects the owner from double commission liability. Example: a homeowner signs 2 exclusive right-to-sell agreements with 2 different brokerages for overlapping time periods. Both brokers procure interested buyers. The seller could be liable for 2 commissions. Discussion. Question: why is it risky for an owner to sign 2 exclusive right listings for the same time period? Answer: because both brokers may claim entitlement to compensation, exposing the owner to double liability. Price section: more than just a number. The listing price sets the marketing benchmark, but does not guarantee sale at that price. It frames negotiation expectations. For rentals, specifying inclusion of transaction privilege taxes ensures clarity. Failure to address taxes may create disputes over rental pricing. Strategic example from the Valley. In a competitive Chandler market, listing at $499,900 instead of $505,000 may position the property within a popular search bracket and drive multiple offers. The listing price is strategic, not emotional. Term section. The clock matters. The commencement date and expiration date define when the broker's authority begins and ends. Under Arizona law, listing agreements must have a definite expiration date to be enforceable. An open-ended listing could be deemed invalid. The automatic extension through closing protects the broker's compensation if a contract is signed just before expiration, but closes afterward. Example: a listing expires June 30th. A purchase contract is executed June 29th with a July 30th closing. Without extension language, the broker's authority might technically expire before closing. This clause protects against that gap. Discussion question: why is it important that the expiration date include a specific time such as 11:59 p.m. MST? Answer: to eliminate ambiguity. If a contract is signed at 8 p.m. on expiration day, there is no dispute whether the listing was still active. Capacity, authority, and legal power. This section is one of the most overlooked but most important. The owner warrants they have legal capacity and authority to sell. If a property is in probate, subject to bankruptcy, or owned by a minor, capacity issues arise. Under ARS, paragraph 14-3715, probate authority, a personal representative may have authority, but documentation is required. If the owner lacks authority, the broker may spend months marketing a property that cannot legally transfer. Example: a son lists his elderly mother's property without a recorded power of attorney. A buyer goes under contract. Escrow discovers no authority. The transaction collapses. Discussion. Question: what document should you request if someone is signing on behalf of another person? Answer: a valid recorded power of attorney or legal documentation showing authority. Modification: protecting against verbal changes. This clause reinforces that modifications must be in writing. Arizona contract law recognizes that written agreements may require written amendments. Verbal extensions or commission changes create risk and dispute potential. Under ARS, paragraph 44-101, agreements concerning real estate employment must be written. This supports enforceability and clarity. Equal housing opportunity, legal compliance is mandatory. This provision reinforces compliance with the Fair Housing Act and Arizona fair housing laws. Discrimination based on protected classes is illegal. Under AAC, R428-1101, licensees must protect the public and avoid unlawful conduct. Violations can result in discipline under ARS, paragraph 32-2153. Example: a seller instructs a broker to avoid renting to families with children. The broker must refuse and educate the seller. Following such instruction would violate federal and state law. Discussion. Question: if a seller requests that you market only to retired couples, what is your proper response? Answer: Explain that such selective marketing violates fair housing laws and refuse to comply. Connecting this section to the marketplace. Remember Section 1.1. Market knowledge influences listing price and term decisions. Legal knowledge ensures the listing is enforceable. Together, they protect compensation rights and client interests. A poorly completed listing agreement can result in lost commission, breach of fiduciary duty claims, ADRI complaints, litigation. A properly executed listing agreement creates clarity, authority, and protection.